significance for us as practitioners in this area that Chief Master Marsh adopted what he called an iterative approach to providing guidance. This wasn't a case where the executors went, or the PRs went, with straightforward, this is what we would like to do, please tell us whether we can do it. It was more iterative in the sense of, what shall we do? What is the correct approach for us to take? Master Marsh, there were 4 hearings before him in total. And to start off with, he directed undertakings as to how survivors might have an opportunity to make the claim. One point of significance is that, of course, there was a lot of evidence that was put before the court, which of course was public. This isn't court of protection, public hearing. And of course, those documents, once filed at court, become public documents. He did make an order that no third party was entitled to obtain copies of the witness statements or experts' reports in this case without making an application on notice, an application to him, but on notice to the executors. And so, of course, the first point that had to be considered in relation to directions, the real dichotomy here was there have been no claims intimated or made. Did the executors have to do anything more? Could they simply distribute the estate on the basis, well, he may have been a paedophile, but nobody had sought to claim, or did they have to do more? So the obligations of the claimant, I imagine you're familiar with. Having got the estate of the deceased, the PR must ascertain the debts and liabilities and arrange for payment in due course. Of course, we all know Section 1, whether we know that it comes from Section 1, that any cause of action subsisting or vesting in the deceased at the date of his death survives for the benefit or against the estate, the one exception being defamation. So the primary consideration for the court was said to be whether the claimant should take reasonable steps to identify creditors of the estate, and if so, what those steps were. Interestingly, Chief Master Marsh found that the protection afforded by Section 27 of the Trustee Act, that I'll come on to, was a secondary consideration. There is, of course, and many of us are familiar with the statutory form of advertising. The concerns here were twofold, one of which is that the prospect of being seen or significantly acted on by victims of historic abuse was considered to be extremely slight. And also there was concern that the protection afforded by Section 27 might be limited. It was unclear whether they would be treated as having notice of a class of claims which they believe may exist, in relation to which the identities of possible claimants was unknown. There was a contrast drawn and made with the case of Jimmy Savile's estate. In that case, there was no direction given, and indeed no suggestion that there needed to be any wider advertising. Of course, it was all over the mainstream media, and that within 6 months of death, there had already been 124 potential claimants who had come forward intimating claims. Here, despite it being 3 years since death, nobody had come forward with a potential claim, and despite extensive investigations, the PRs had been unable to identify any potential claimants. So what approach should the court take? Well, the executors have to look at a reasonable probability of there being future demands on the estate before being allowed to distribute. And it was said that the court should take a practical view, even as against executors who asked for better protection, that no retention or security beyond the personal liabilities of beneficiaries was needed. And that, of course, came from the Waller case. So what did Chief Master Marsh say? Well, he said the duty placed on administrators to pay the debts and liabilities of the estate isn't absolute. The administrators only need to be required to take reasonable steps, and the court will take a practical view when it comes to that. However, they will vary, depend on the circumstances, the nature of liabilities, and the degree of likelihood they exist. Court will balance the need to pay debts and liabilities with the reasonable expectation on the part of beneficiaries they will receive payment. And so here there had been an extensive report commissioned by the claimants from another solicitor who specialised in historic child abuse cases. And there was sufficient evidence for Chief Master Marsh to determine at the third hearing that Michael Studdart had committed historic sexual assaults in England and Wales and outside the jurisdiction in Poland, Denmark and Italy. He therefore ordered at the third hearing that no further distribution was to be made. He'd ordered at the first hearing that some very small pecuniary legacies could be paid. And in essence, the conclusion to this case is that dedicated websites in English, Polish, Danish and Italian languages, along with entries on Twitter, Facebook and Wikipedia to signpost claims towards the website were made. That website, as was confirmed at the end of the judgment, was set up, michaelstuddart.org. And there has, as of yet, been no deadline put on when distribution can take place. Applications having to be made back to the court in the future to release that order not to distribute. One of the things that I have no doubt made a difference here is the fact that the ultimate beneficiaries will be charitable aims, and therefore we don't have particular beneficiaries chomping to get their inheritance. So I do suspect that if there had been specific beneficiaries who were due to inherit, that we might not have seen such a wide-ranging order in terms of time, i.e. that no time has been placed on. But it's certainly an interesting case when it comes to advertising. Clitheroe Bond, back before you again. You may remember this. The shopaholic ex-Lloyd bank manager wins fight with estate agent brothers for half her mother's 325k estate after she was cut out of the will. There were two wills that were being challenged here. I'm not going to go through it all with you, but there were two wills drawn in 2010 and 2013 that sought to exclude the shopaholic, or allegedly shopaholic, daughter who was accused by mum of having stolen from her. The reason it says their eldest daughter died in 2009 was because mum suffered, I don't think there's any doubt that he suffered a complex grief reaction to the diagnosis, the terminal diagnosis of the eldest daughter in 2009. And her attitude towards Susan changed irrevocably after that point. So why am I troubling you with this case again? Well, it's because we understand from press releases that have been put out by two chambers, one of which is 39 Essex chambers, that Mrs. Justice Fawkes has recently granted permission on paper for appeal to the Court of Appeal. I've put there for you the quotation from, or the extract from 39 Essex Street, partly because Matthew and I don't agree with them about the significance and the likelihood of success of appeal on this one. So it's not my words, it's theirs, but they've said, amongst other things, one of the grounds on which permission has been granted, and I don't deny that this is the ground permission has been granted, is the contention that a proper test for testamentary capacity is that under the Mental Capacity Act 2005, with a presumption of capacity, rather than pursuant to the test in Banks and Goodfellow, which they say transfers the burden of proving capacity to the person who claims the will is valid, if a real doubt is raised. The outcome of this appeal may have a significant effect, this is the bit I challenge, on the validity of wills generally, and is therefore of considerable general importance. I won't go through my view, particularly given that it's being done, other than to say my understanding of what happened in Clitheroe and Banks, and certainly Key and Key, and I have included for you the slides that will be passed, that will be emailed round to you. You will see that I have included the slides that I spoke about in August. So I'm not proposing to take you through those today, but you can see the approach that was taken, and I think in particular that it will be this, it will be the approach that the court took, which is whether or not the approach of Williams-Mortimer is correct, or Williams on wills. So I've put those in for interest for you, but as I say, I know many of you have already attended the talk, and it is available on YouTube. We could send that round to you if you want to hear more about the original decision in Clitheroe and Bond. But many of us have been advising using Clitheroe and Bond, and so it's something to be aware of, that it looks as though there is a date coming up There's certainly my own experience at the moment, the Court of Appeal are taking about 18 months from having granted permission to actually hearing decisions. So whether we will see a decision in 2021, I'm afraid I wouldn't have much confidence. The third case then that I'm going to talk to you about is In re Barry. Mr. Barry was a professional racing car driver, and the defendant in this case was, the claimant is the executor of his will. And the defendant in this was the British Racing Drivers Motorsport Charity. So he was a professional racing car driver who died in September 2018. He was survived by his fiancée and long-term partner, Catherine, and his 105-year-old mother. Now, it took me ages to figure out, and I'm still not sure I've written that correct. His mother and Catherine are not the same person. This is one of those eat, shoots and leaves type situations that counsel should definitely know. His mother and Catherine are different people. He is survived by his fiancée and long-term partner, and he is survived by his mother. So anyway, back to, we've got a will that provided for Catherine to live in their house for the remainder of her life. His mother gained a share of another property that he partly owed. There was some small pecuniary legacies, but the residue was to go to the British Racing Drivers Club Benevolent Fund and the Cancer Research Fund. Neither of those organisations exist, certainly not as charities. Hence the reason that this came before the court. There was an IPFDA that was being intimated. I think it had actually been issued by Catherine, but of course, until it had been determined whether or not there were charities that could inherit, where the residue was going, her claim can't really get any further. Surprisingly, given that the will was not that old, the original will file had been destroyed, and so the court was unable to look at the instructions that had been given. Not surprisingly, Mr. Justice Matthews looked at Section 21 Administration of Justice Act and also at Marley and Rawlings. So let's look at the first one then. So the first one is the British Racing Drivers Motorsport Charity. So the residue was to go to the British Racing Drivers Club Benevolent Fund. And what we have is the British Racing Drivers Club, which isn't a charity, but did administer a benevolent fund. And actually, it was unchallenged by everybody that that was who he was intending to benefit. Mr. Justice Matthews held that this was a straightforward construction of the will position, that the British Racing Drivers Club Benevolent Fund linked the identity of the intended beneficiary to the club, and the motorsport charity was the only benevolent fund administered. So, and concluded that in that case, it was a simple case of construing the words in the will in the context in which the deceased used them in order to ascertain the proper construction of the will. The second one then is the Cancer Research Fund. It was held that that phrase was ambiguous and therefore did necessitate the application of Section 21. It wasn't possible to construct what was intended, to construct who might have been intended to benefit. And it was concluded that there was no particular institution that was relevant here, but that it was for the executor to apply the part of the residue for the charitable purpose of cancer research. The final case then that I'm going to talk to you on is Her Majesty's Attorney General and ZRD, Finance Services. This is the decision of Mr. Justice Zaccaroli. And it's interesting because it's a trust or a fund that dates all the way back to 1927. The identity of the benefactor was certainly, when it first came to the court, had remained out of the public domain. It has now come into the public domain and is dealt with within this second judgment. The first judgment that came down, I believe, in October, was an application to join the second and third defendants. They were beneficiaries or potential beneficiaries, being blood relatives of the original the original benefactor all the way back in 1923. Zedra were the current trustees of the trust fund. The trust fund had been £500,000 back in 1927, but was now worth some 400 million. And the two main claims that were brought for directions by in this case were whether the court had jurisdiction to make a scheme altering the trusts contained in the deed, and if so, whether that was under the court's main administrative jurisdiction or whether it was under the 2011 Act, the CPRES jurisdiction. And so we have the Attorney General contending that the deed created a valid charitable trust, and the national fund that was created, in essence, was to pay off the national debt, something that many of us might all be quite grateful if it could be done. 400 million, as I'm sure you know, is a large sum of money, but he's not going to touch our national debt in great detail. And so defendants 2 and 3 were joined at this hearing for which the judgment came down in October, before there was then the disposal hearing in November. And the blood relatives of the original benefactor disputed the validity of the original deed and contended that the national fund was now held on trust for the donor, and there had been additional donors after the original 1927 creation of this national fund or their estates. The first defendant, the current trustees, contended that the trust was valid as a charitable trust, but disputed that even if it, and said that the court could and should order the national fund to be applied, disputed that the court should order that the national fund be applied to reduce the national debt, which is what our Attorney General, in her wisdom, was seeking. So there were two validity issues raised, and then if the trust was valid, if those failed, did the court have jurisdiction, and if so, what power did that jurisdiction come from to help determine how it should be administered? And the court found that the deed was valid, it was a charitable gift, that there was no condition precedent that the national debt be capable of being repaid in full by the fund, and so it was held that it was valid and had always been valid. The court then went on to determine whether or not it had the power to administer a different scheme. And the court found, as you'll see at 4, that it did have jurisdiction to make a scheme altering the charitable trust, that it wasn't pursuant to its administrative, general administrative powers, but under the 2011 Act. And therefore the question for the court whether it should make a scheme for the transfer of the national fund to the national debt for the reduction of the national debt or for some other purpose, and if so, what charitable purpose, has been deferred to a subsequent hearing. So we're still waiting to find out, for those of us interested, whether or not, in fact, this 400 million will be paid out at this point. It seems from what the court has said so far unlikely that the court is going to order the ending of this charitable trust in circumstances where the trustees are not pushing for that. It is only the Attorney General who seems to want to do that, but in full. But of course, the court has the power to order the transfer of some of the 400 million that is remaining, or certainly to give directions as to how and in what circumstances that should be paid. So a brief summary there of 4 recent cases for you, something by way of an update. And with that, I'll hand over, if I can, to Matthew. Is that transferred back to you, Matthew?